Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann and I are back once again. Ann, of course, is a law professor at the University of Colorado who teaches and researches securities and business law, and she looks after all the law, the legal end of our podcast.
All the law.
All the law, every law, or every securities law.
Yeah. And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Yes.
And I will say and remind people that we have an email address, shareholderprimacy, one word, at freefloat.llc. If you'd like to send us things that you'd like us to answer or talk about on the show.
Or complaints or gripes or whatever.
You can send them.
Just let us know. People do that. So we have today a really interesting subject. It starts off a little, shall I say, arcane, and gets
not to me.
No, I know that, but it's. I mean, to other people, it might start off a little technical, but it gets really interesting and very impactful as we kind of dig into it. So let's talk about mandatory arbitration.
Yes.
As a way to resolve our controversies and disputes. So the reason we decided to talk about this now is there was the proximate event, or the proximate reason, was the SEC just in the past several days announced they either are considering or they in fact will allow companies to do an IPO, to go public with, let me make sure I get this right, mandatory arbitration provisions in the corporate constitutive. Just
charters and bylaws.
Charters and bylaws. So let's talk about that. What's the issue? Why? What is it? Why do companies like it? Take us through this.
Yeah, so let's start with arbitration. It's just an agreement to resolve a dispute, like a legal dispute, outside of a courtroom, usually in secrecy, with more abbreviated rules than a traditional court. It's not a mediation. It's not a settlement negotiation. It's like a little mini trial, but it's done just outside of a courtroom, in private, with just far less formal rules. And there are a lot of reasons why a party would rather arbitrate their disputes than try them in a court. It's faster, it's cheaper, and it's much more private. But they're totally legitimate reasons to choose to resolve disputes in arbitration. But what companies like to do is stick arbitration clauses in contracts because that require any disputes that come up to be arbitrated, because they can also add to that those disputes will have to be arbitrated on an individualized basis and not in class action. So there's a difference between, this is why we call it mandatory arbitration. So there's a difference between two parties of equal bargaining power sort of having a dickered contract and agreeing that they're going to resolve their disputes in arbitration. That's one thing. But the issue that comes up is when companies that are drafting the contracts, like that are mass contracts, like maybe consumer contracts, things like that.
Oh, sure. Like your agreement to sign up for a mobile phone plan or something.
Exactly. Your mobile phone plan, your iTunes plan, your credit card, your car loan, whatever it is. And they all require arbitration. But what they do is that they say, and this replaces class actions, so that every dispute has to be individual and you can't bring your claims as class. A lot of small consumers, retail disputes are simply not feasible economically to be brought individually. The only way they make economic sense is to bring them as class actions. Right. So what companies get out of this, it's not that they want the arbitration. I mean, I'm sure they're happy to have a private secret tribunal, but that's not the point. The point is to kill class actions, because once you say that disputes have to be brought individualized basis, then they just won't be brought at all. So the arbitration is really, it's the mechanism to make it impossible to bring a class action.
To do some sort of mass action. So
exactly.
Okay. So the idea here, go ahead. I'm sorry.
No. So I was just going to say that, so when we talk about mandatory arbitration, the reason the phrase mandatory is placed in front of it is because the theory is that it's put into contracts, but they're not ones that anyone really negotiated or had an ability to fight about.
I remember those as being, is it right to call those the contracts of adhesion? Where
contracts of adhesion, exactly.
I learned something in business law.
Yeah, as opposed to what we say dickered contracts, which are viewed as the ones you actually negotiate.
Bargained, dicker, bargained.
Yeah, exactly. Right. So in this case,
the point is to take this out of the realm of me, individual consumer, having to hire a lawyer, build a case. I could do that. I could sue somebody, but that's complete. No one will take that case. It's completely impractical.
Exactly.
So we used to go and form a big class. There's lawyers that shop for this stuff, and the antidote to that, if you're the company, is to say, no, we're going to arbitrate this, but it's got to be one. And arbitration is by its nature not a class type thing. It's a one by one kind of
there is such a thing as class arbitration, but essentially over the years, the Supreme Court has made clear that when you write an arbitration clause, you can also write in that it must be individualized. You can't do that for a court action.
All right.
So the idea now, when we're talking about the securities realm, is
right.
So
let's look at the contract that's between me and the company. And I always say this is not exactly right, but it's sort of a good way to appeal to your intuition. Is the bylaws are kind of sort of maybe a little form of contract between me as shareholder and the company.
Yeah. So this is the idea. So the idea is that companies wanted to have individualized to kill the securities class action, basically, to kill the ability of shareholders to bring claims under the federal securities laws, Section 10, Section 11, for false statements. The only reason those are economical to bring is because they're almost always brought as class actions, and companies really wanted to kill the class action, but that means you have to have a contract in which to put the arbitration clause. And the only contract that exists really for open market purchases of securities are, as you say, the charters and bylaws. So there's been this longstanding and somewhat tortured legal question about whether charters and bylaws would count as a contract into which you could insert the arbitration clause that would kill the class action by saying all securities claims would have to be arbitrated on an individualized basis.
All right. So what's practice been up till now, I guess?
Yeah. So up till now you haven't had them because they've got this So several years ago, Delaware passed a law that said Delaware started allowing you to put not arbitration but forum selection clauses.
Oh, interesting.
In your charters and bylaws. Now, the difference between a forum selection clause and an arbitration clause says you have to arbitrate and can also say individually. Forum just picks a court. It just says normally you could go to any court in the country, but now we're going to funnel all claims into one particular court. So several years ago, Delaware passes a law that says you can put a forum selection clause for Delaware state claims in your charters and bylaws that would funnel all claims to a particular court, like Delaware court.
Right.
But it
doesn't have to be Delaware, though, right?
It does. It has. You can't deny access to a Delaware court, but you can add a court. So you could say Delaware and Virginia, but because Delaware did not. Actually, the reason they passed the law was because a company chose North Carolina exclusively, and Delaware's, oh no, that's not okay. You can't take Delaware out of the equation.
We want the litigation here in Wilmington.
Exactly. So now but this was only for Delaware, like your standard fiduciary duty claims, not federal securities claims. So it wasn't clear whether you could even write a charter or bylaw that would govern securities claims. Because the charter and bylaw, even if you view it as a contract, it's a contract about this state entity, and it wasn't clear that you could deal with federal securities claims in your charters and bylaws. Aren't charters and bylaws supposed to be about state law? So, but then eventually in a case called Salzburg versus Shabakuki, which nobody can pronounce, but it's Shabakuki. Yes,
Shabakuki, that's a defendant?
That was the plaintiff. There's the Shabakuki won in the Chancery Court before Vice Chancellor Laster. Okay. Salzburg, which was the company
sounds like a bakery. Shabakuki.
Yeah, I know, but it's actually not spelled anything like what it sounds.
Oh, good. Okay.
So in Salzburg versus Shabakuki, the Delaware Supreme Court said you can, in fact, have charters and bylaws that allow a forum selection clause for federal securities claims. In other words, you can require that federal securities claims be brought in a particular forum, a particular court, just by putting that into your charter and bylaw. And this is the point where I have to say, it's a terrible opinion. It's a terrible opinion. I mean, here's the thing. It really confuses, and this is coming from Delaware, it's a little surprising that it kind of confuses charters and bylaws in the opinion, because it starts out by, because one of the major differences between charters and bylaws is charters can only be amended with a shareholder vote.
Right. Charters are shareholder approved. Bylaws can,
bylaws
goes.
directors can just pass them unilaterally. Right. And so one of the things the opinion does is it says, well, charters and bylaws are just like contracts. And they go on about charters being just like contracts because shareholders approve them. And then it just throws bylaws in. And you're like, wait, but they didn't approve the bylaws. So it's just, anyway, nonetheless, there's really sketchy on bylaws, but charters you can. And then it was really unclear which federal securities claims are going to be covered under this. But after that decision, courts around the country took that case to mean, yes, you can put a forum selection clause that covers federal securities claims in your bylaws and charters, including these unilaterally passed bylaws by directors, and that was okay. So that really opened the door at the state level to authorizing it under Delaware law or state law, to authorizing potentially mandatory arbitration in forums,
okay. So it's a short
charters
step.
And bylaws.
It's a short step from forum selection to arbitration.
Exactly,
basically.
to arbitration. But that was just a state law development.
Okay, got it. So we've now talked a little bit about Delaware, I think. Okay, but this is all federal actions, right?
Yeah, right.
Okay.
So then the next issue though was, okay, well, if Delaware, the door is open anyway. If Delaware, the door is open, what's going to happen? How does the SEC feel? And there was this additional barrier. So this requires a little bit. I'm going to get detailed about the federal securities
I told you.
laws.
I said it was going to be a little arcane and technical, wasn't it?
It is. It's going to be arcane and technical.
But I promise everyone we will come back to the broad implications.
Yeah, because the general reporting, which it's fine, is that the SEC banned arbitration clauses in IPOs, and that's not exactly what happened. But so I'm going to be technical about this. So you have to start with, the federal securities laws are very old. And the Securities Act.
They go back to 1933, 34.
It was passed in 1933. The Securities Act was passed. That's almost 100 years ago.
I was going to say, God,
and it was nothing like it had ever happened before. So nobody knew how it was going to work. And one of the things that this very old statute says is, the company can't sell securities to the public unless they're registered. You file a registration statement.
That's the essence of what the SEC does, is they track this stuff. Yeah,
exactly. Right. And the way the statute is worded, it actually says that you can file your registration statement, and unless the SEC takes action to stop you, that registration statement will automatically become effective after 20 days. So you file your registration statement, you wait 20 days, and then you can sell your securities. But that turns out to be, in practice, almost immediately they figured out in practice, terrible. Because the SEC often has questions and problems with your registration statement, and 20 days is simply not enough to resolve them. And nobody wants to go public and then have the SEC come after them and say there was a problem with your registration statement.
Right.
Plus, today, I mean, think about it. Pricing and how the price you're going to charge and the number of shares you're going to sell, that's not absolutely settled until the very last minute. Nobody wants to put in their registration statement how many shares they're selling and at what price, and then wait 20 days. Like the whole market can
shift. Yeah, we've seen
exactly. That. So this idea that you can file and wait 20 days just doesn't work. So instead, companies in the SEC worked out a different system. And the system is that the company will agree not to have their registration statement become effective until the SEC has worked out with them whatever problems and questions the SEC has. And once that happens, the SEC will accelerate the effectiveness. They'll skip the 20 days and say, okay, your registration statement is ready now, and then the company will sell. And that way the company can get a date certain that it knows in advance and quickly sell as soon as it settles on pricing. And that process is called acceleration of the effectiveness of the registration statement. Okay. And what the SEC developed a policy of back in certainly around 2013, 2014, maybe earlier, but that was there was a big blow up about this. It decided it was very uncomfortable with the idea that companies might put mandatory individualized arbitration clauses in their charters and bylaws. So it said, we're just not going to accelerate the effectiveness of your registration statement if you have them in your company constitutive documents. So nobody went public with these things in their charters and bylaws. But that didn't stop them. Nothing stopped them from adding them later, especially in a bylaw, which directors could pass unilaterally. But nobody ever did. And presumably
that's interesting.
Yeah.
So
Yeah,
Okay, go ahead.
nobody ever did. No, well, I think there are a couple of obviously there have been agitations. There was one particular. There's a law professor, Hal Scott at Harvard, who was actually really urging companies to adopt these once they were already public. But the problem for companies, the idea is they knew they would get into a fight over whether they were enforceable. They knew they would get into a fight with the states because at this point it wasn't clear it was legal under Delaware. They knew they would get into a fight with shareholders over it, and they knew the SEC hated it. And the last thing they wanted was to get into if the SEC says, "Oh, you've insulated yourself from shareholder class action. Should we take a closer look at your financial statements?" I mean, nobody just wanted to pick the fight.
Right.
So even though they always could have passed those after they were public, they just didn't bother. And the other reason is they are more valuable at the IPO stage, and this is why. There are essentially two kinds of claims that are brought as federal securities class actions: Section 10B claims and Section 11 claims. Section 10B
You're going to tell us what those are. Okay, go.
I am going to tell you what they are. Section 10B claims are what we normally think of as federal securities class action. It's for fraud, and you can bring it this is the kind of claim that, is your usual vanilla company lied about something about its business, and there's a federal securities class action.
Right.
Section 11 claims are specific to registration statements, false registration statements. So they're almost always brought for the IPO stage. And they are easier for plaintiffs to bring and harder for defendants to defend against because they do not require a showing of intent. Section 10B requires that the company have intended
like your
to
state
make
of
false
state of
statements.
mind kind of stuff.
State of mind, exactly. But Section 11 does not require a showing of intent. And that is basically a claim that can, for the most part, only be brought when companies are going public. So if you can't put these in your documents when you go public, you can't protect against Section 11 claims. At most, passing them later will protect you against Section 10B claims. But Section 10B claims are already sort of hard for plaintiffs to bring because they have to show intent, and they're just harder for plaintiffs. So the balance of risks versus benefits of adding them after you're already public, given the SEC's obvious dislike of them, companies didn't bother. So arbitration kind of fell out of favor. Like it wasn't on anyone's radar screen. No one was paying attention to the idea.
Right. Even though, and we're going to talk about this a little bit, even though class actions, and I think, is it fair to talk about their first cousin shareholder derivative, or is that going to be?
Well, that's state law. So that's usually state law. That's almost always like that goes. Those are almost always state law.
Fair enough. But companies, as much as they dislike activists, they really hate class action securities.
They hate class action. Well, the potential damages are enormous. There are actually a lot, like over the years, companies have gotten a lot of legislation passed that makes them harder and harder and harder for plaintiffs to bring. And courts tend to be very skeptical of them. So really, a lot of these cases get dismissed. They don't go far. But if they manage to make it to pass the motion to dismiss and class certification, the potential liability is very
immense,
large.
Yes.
And that's why and they usually settle at that point.
Right. So even though there was this kind of underlying worry among boards and companies, they didn't do much about it because of all these, what I'll say is sort of procedural, these are kind of hurdles they had to go over.
It just wasn't it just wasn't worth it because it wasn't clear they'd be legal, and even if they were fighting with the SEC over it for a potential future claim that may or may not be brought, they obviously didn't think it was worth having a fight over.
Got it. And then before we get to the recent SEC news, there was some more Delaware stuff, right? That sort of preceded this? Okay.
Yes, and this is what just happened was why it's so funny, because really what we're living now is in a state where after a big sort of fight about this for a few years in like 2014, 2015, essentially companies forgot about it. Like they just weren't bothering with arbitration. Nobody was worrying about it. And then Delaware changed its law again. I'm going to try to avoid getting too far in the weeds, but let's just say that a couple of companies had these bylaws that suggested certain federal securities claims they could do forum selection. So the forum that they selected was Delaware Chancery. That is a problem because for some federal securities claims, you can't bring them in state courts, like at all. Like the state courts just don't have jurisdiction. Okay. So if you have a forum selection clause that says these securities claims have to be brought in the Delaware Court of Chancery, what you're functionally saying is they can't be brought in any court at all because the only court you're allowing them to hear.
You're barred from filing any claim by
exactly.
Interesting.
like only like two companies even bothered to make this argument, bothered to try this. Only two. Or no, a couple more. Like it was a handful of companies that tried this. One court, the Ninth Circuit, actually allowed it. Actually said, "Oh, I guess there is a forum selection clause. I guess it does say the Delaware Court of Chancery. I guess that means you can't bring your claim. Sorry, plaintiffs." But for the most part, it was such an obscure little thing, and it was such an obscure little issue that most companies weren't even bothering. This is just too silly. So here's what I think happened in Delaware. We know there was this huge fight in Delaware recently about SB 21 and making it harder for plaintiffs to bring actions. That was all state law. Delaware changed its law. It was a huge, ugly fight. And I think
that was just earlier this year. Just to
that was early this year.
That was just a few months ago. How soon we forget?
Yes, exactly. And also the year before, there was this shareholder
thing
agreement
about
thing.
Right.
It was basically the defense bar muscling through a lot of changes to Delaware law that were very, very damaging to plaintiffs. And I think they wanted to essentially throw plaintiffs a bone after this. See, we're fair and reasonable. This tiny little corner where a couple of companies for this tiny little obscure kind of situation were able to essentially completely fend off securities actions by shunting them all to the Delaware Court of Chancery, we'll ban that. And the way they banned that was by saying, if you have a forum selection clause in your charter or bylaw, or if you have a selection, some kind of a clause in your charter and bylaw that governs federal securities claims, you have to give access to at least one Delaware court with jurisdiction to hear the claim.
Okay.
In other words, you're not allowed to, what they meant was to say you can't shunt all claims into a court that has no jurisdiction to hear them. But the way they actually wrote it was you have to give access to a court, not an arbitral forum, a court, which means they are essentially saying you can't pass a charter or bylaw that exclusively requires arbitration because you have to leave open access to a court.
To a court. That
Exactly.
word court is critical here.
The word court is critical. They weren't thinking about arbitration. They were thinking about this situation where a couple of companies shunted all claims to a court that had no jurisdiction, which was such a tiny thing that companies weren't even trying.
So they said, okay, fine, you pick a court in Delaware and you can file here.
But because they weren't thinking about arbitration. But now Delaware law technically prohibits mandatory arbitration. It prohibits a company from adopting a charter or bylaw that requires individualized arbitration of federal securities claims because your charter or bylaw has to give access to at least one court in Delaware with jurisdiction to hear it.
An arbitrator is not a court, is not a judge.
An arbitrator is not a court, exactly. So people have asked me, this isn't like people have asked me, is that the only way to read the statute? I'm like, well, that's the only reasonable way to read the statute. If you read it any other way, you would like upend other parts of the law. I mean, it just doesn't make any sense. Like, yes, that's what the law says currently in Delaware. But this just took effect. It just took effect September 1st. This was a law that was passed over the summer.
So this is part of SB 21, of course.
Well, that was right after SB 21. As I said, I think they was sort of like supposed to be a SOP, like, look how reasonable we are. We aren't barring all shareholder claims.
Right.
But they wrote this statute not thinking about arbitration because arbitration wasn't on the table.
And then the SEC stepped in.
And then the SEC shifts its position. The SEC just, recently announced we will no longer refuse to accelerate the effectiveness of IPOs just because they have arbitration clauses, meaning that you can now go public with these things in your charters and bylaws. And I think it sort of sends a permission to companies that were refraining from adopting them midstream. The SEC will not get on your case if you choose to adopt them midstream.
Right.
So now companies, they could always do it, but now they kind of have permission from the SEC, except they can't in Delaware because Delaware's law just took effect on September 1st. So if they are incorporated in Delaware, they actually can't.
Oh, so there's a little bit of a contradiction, at least as regards Delaware corporations.
Yeah, but the SEC, like, it's not a contradiction, but it's just like the feds won't have a problem with it, but Delaware will, according to Delaware law right now. But the SEC almost called out Delaware. So Paul, the chair of the SEC, Paul Atkins, when he made this statement, is kind of like, of course, we're not talking about state law. Apparently, they're banned in Delaware. Other states may do things differently, et cetera.
Okay. Wow. All right. So that's a decent foundation to try to understand some of the implications and where this goes and so forth. But let's do that after a break.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're talking about mandatory arbitration of securities claims in corporate bylaws and charters.
So just to make sure, again, I actually am involved. I'll talk about it in a minute. I've been involved in the Tesla litigation, as you know, which is
wow.
Okay. But I've been involved in some other litigation in another company I'm involved in to compel an AGM. I've actually talked about it more with some friendly attorneys and so forth. It's becoming increasingly more like top of mind for activists.
Okay. Yeah.
About is there a litigation angle to escalating some sort of a case against a company or some sort of an activist situation.
Right.
So
and remember, and we talked about those the 16B claims in the Massimo.
Oh yeah, sure, exactly.
Right. That was federal here. I mean, because we're talking about federal and state. Yeah.
Right. Yeah. So there's more of this. This is relevant, increasingly relevant. It used to be completely almost irrelevant to activists. But activists are considering this a little more, adding it kind of to the toolkit, if you want to call it that. So let's now that the SEC basically is going to allow IPOs, just to summarize,
and it's allow IPOs with
the mandatory arbitration clause,
and that the implicit threat from the SEC has been lifted for past IPO stages. So public companies that are public now have more permission to add them. They could always do it legally, but now they have that permission. So now we're in a world where it's possible.
So I'm guessing that, again, I know companies are positively allergic to these kind of cases, and for the reasons we talked about, it's an enormous hassle. It's very expensive to try to work these. And the potential damages are enormous. So I'm guessing that the at least initial reaction has been jubilation. Is that the right?
That's the right word. I don't know. I honestly don't know. I mean, I kind of have been waiting for like the first company to pass a bylaw requiring arbitration was got to be Tesla because it's not in Delaware anymore. It's Texas. Right. I've been waiting for the Tesla 8K to drop saying we've changed our bylaws. But actually, I think part of the reason they haven't. I mean, we'll see. But at first I thought, like, okay, where's the Tesla 8K? Isn't Tesla going to be the first? Tesla gets slapped with securities fraud lawsuits all the time. But it actually occurred to me they've got this upcoming shareholder vote on Elon Musk's pay, so they may not want to like be in the news for suddenly adopting.
They may want to focus on other things in their.
They want to wait for that until the shareholders vote on that. But so there's a lot to consider. So like leaving aside the legalities, which we'll get to, which we're definitely going to get back to, but leaving aside the legality. There's first of all, there's a question of whether companies really want to do this. So a lot of lawyers have suggested that maybe companies don't actually want this. Because here's the reason why. The reason you require the reason you require mandatory arbitration individualized is to avoid class actions on the theory that almost no one's going to bring it individually. So then you've gotten rid of all litigation. And that's often true in the consumer space, although to be fair, there are some attorneys who have gotten very creative of figuring out how to join together lots and lots and lots of individual arbitrations, and that can be even more expensive than a class action.
Right.
But the question is whether this idea, well, no one's going to sue individually, so you've essentially gotten out of lawsuits, may not be true when we're talking about securities cases, because you have institutional investors who may in any given case have hundreds of millions of dollars of losses, at least on paper. And so one possibility is that if you shunt all the claims into individualized arbitration, now what you're facing is lots and lots of claims by multiple pension funds, say, each one of which has to be handled individually.
Big hedge funds or something. I mean, there's
well, I don't know how likely there are, but certainly the pension funds. Each one of them is handled individually. There's a lot of money in each case, so it may be worth it to bring. And the thing about arbitration is they are procedurally streamlined as compared to trials. And that sounds good most of the time. But securities class actions have gotten such a bad reputation for being sort of nuisance suits that the laws have changed to build up a lot of procedural barriers to shareholders bringing them. Shareholders have a lot of procedural roadblocks in court before they can get to the serious actually litigating.
Sure, you got to survive the
motion to dismiss,
and there's all sorts of evidentiary stuff. Yeah, right, okay.
All that stuff. And that doesn't exist in arbitration. So companies actually have certain protections in court that they don't have in arbitration, and they would have to deal with potentially multiple claims by large large pension funds.
Right.
And maybe that is more of a hassle than having to deal with this as a class action.
So be careful what you wish for, kind of.
Exactly. But I suspect most companies would just rather roll the dice and at least try it. Nonetheless, there is that argument out there that they actually would rather take their chances in court where they have so many procedural protections and they can knock out the entire case with one blow.
Okay.
So that's the first issue. Do companies even want this?
Right.
The second, though, issue is, once again, leaving aside Delaware's law, you can't do this in Delaware right now. It's still not entirely clear they're enforceable. I mean, the fact is that there are a lot of legal questions about just how binding these are.
Oh, these
that haven't really been tested.
Whether the bylaw amendment would be enforceable.
Yeah, exactly.
Right.
Sure. At this point, a lot of courts have enforced forum selection clauses, but let's just say there are a lot of arguments that could be made that, first of all, some of those forum selection decisions were wrong. I think they were wrong, but whatever. But you could, let's just say that plaintiffs are not going to give up without a fight about whether, even if you pass these, they're enforceable. I mean, the SEC simply said you can put them in your charters and bylaws. This is not a statement of whether they really are enforceable and really do what companies want them to do.
This is just the SEC's not going to give you a hard time
in
registering your IPO.
Exactly.
And then they're going to say, okay, take it to state court and sort of see if you can get it through there.
Okay. It would be federal court, actually. And we just don't know.
Federal. All right.
Yeah, so we just don't know yet whether, let's just say there would be a prolonged legal battle about whether or not it's really enforceable. But then we're left with, they are still illegal in Delaware. But as we have talked about many times on the show, Delaware is locked in this competition for charters. It's very paranoid now about losing charters to other states, to Texas, and I don't think it's going to lose to Texas, but Nevada,
or Nevada,
and maybe somebody else.
Yeah, right.
Nevada may be more plausible. And these states are going to roll out the red carpet, I think.
Oh, and say, mandatory arbitration, come bring it on.
Yeah, exactly. So Delaware presumably wants to, so I think there's going to be pressure on Delaware to change this law. And I actually saw some random Silicon Valley person on LinkedIn immediately post, Delaware, are you going to change it? I think there's going to be pressure.
So the Bar Association probably is going to be studying this really hard in anticipation of next spring's legislative session.
If they wait that long. But
interesting. Okay.
But there's even more complications here.
Yeah, okay.
Which is, there is a statute from 1925 called the Federal Arbitration Act. And it basically says that states can't regulate contracts to arbitrate. They can't regulate them, which means Delaware's ban may not even be legal. It is possible, we don't know because it hasn't been tested, that the Federal Arbitration Act prohibits Delaware from prohibiting arbitration.
And no one's ever asked.
Nobody's ever asked. But here's the thing. Remember, when we started this, I said Delaware began all of this, started down this road by requiring access to a court for state law claims, the fiduciary claims. You couldn't arbitrate those. Then it added for federal securities claims.
Right.
If somebody comes along and says, hey, Delaware, I think your ban on arbitration is illegal under the Federal Arbitration Act.
Under this 1925 law.
Yes.
Yeah.
And if Delaware loses, it loses both for the securities one and for the state law one. And then it really loses control over state fiduciary claims, which is very much not what it wants ever. Business sort of made its peace with the one about state law fiduciary claims. Right. But the last thing Delaware wants is for a federal court to say, Delaware, you simply can't ban arbitration clauses. So Delaware doesn't want that tested. So I think from Delaware's point of view, if it at least repeals the securities ban, then it's unlikely anyone's going to make any arguments that its state law ban on arbitration is illegal. And then, and it doesn't care what happens to federal securities claims. So, I mean, I think that, this is why I feel like Delaware's let me be clear. I think we'll get to what I think of these, but it's not that I want to see Delaware repeal this ban on it for securities claims. I just feel like Delaware is going to feel a lot of pressure between pressure from other states and the risk of somebody saying, Delaware, you can't ban arbitration clauses at all.
Ever, right.
Because of the Federal Arbitration Act. Like, the easier way is to just get rid of it for federal securities claims, and then nobody makes any Federal Arbitration Act arguments that will affect the ban on arbitration for state law claims.
All right.
So that's how I game it out.
So there's Delaware may do something.
So I think, yeah.
Here.
And okay, this is where I have to go, I told you so, because I've been writing about this for years.
Yeah. This is something, by the way, this is something you have put a lot of thought into. You've written several papers. You've worked on this when you were in practice. I mean, this isn't like some new kind of novel bit of securities law. This is something you've spent, I would number it in decades.
Yes,
thinking
over 10
about
years now. Yes,
without disclosing, our respective ages. It's something you've thought about a lot.
Yes, and my original argument was charters and bylaws under state law can't govern federal law claims. They just can't govern federal claims. And I think Delaware really, and Vice Chancellor Laster agreed with me. And he was reversed by the Delaware Supreme Court in this case, Salzburg versus Shabakuki. And part of Laster's reasoning, the thinking was Delaware can't really regulate for the world. Like, Delaware has to sort of stay in its lane, and its lane is not governing federal securities claims. And I look and I imagine this is what the alternative world looks like. There's an alternative world where Delaware said that simply as a matter of jurisdiction, charters and bylaws can't control federal claims. Like, charters and bylaws are meant to handle state law matters. They simply can't be used for federal claims. If Delaware had held that, I think every other state would have agreed. This wouldn't have been a charter competition issue because Delaware is so respected. They would have just thought, as a matter of theory, that Delaware is correct, that charters and bylaws, it's a state law issue. It's a state law construction. Right. It can't control federal claims. And then that would sort of be the settled law, and this would be over. But now, because Delaware sort of arrogated to itself the authority to regulate federal claims in charters and bylaws, now it has to get into a fight about
this whole thing up. Yeah, right.
Does it repeal this ban? And let's say that it repeals this ban. The first thing the first time a Delaware company passes a mandatory arbitration law, it's going to get sued for violating its fiduciary obligations under Delaware law. Oh, can you protect yourself against federal securities claims? Delaware prohibits breaking the law. Are directors trying to shield themselves from being caught and breaking the law? I mean, and all of it. So when is it consonant with or not consonant with your fiduciary duties to disallow federal securities class actions? If you're really guilty of the federal securities class action, should you be allowed to bar people from bringing the claim? And Delaware, and those are going to be Delaware fiduciary fights that, it would have been so much simpler if Delaware back in Salzburg versus Shabakuki had said, actually, you know what? You can't use the corporate form to shield yourself from federal claims.
From federal claims, right, exactly. So,
I just keep imagining that Homer Simpson meme where he retreats into a hedge so that you can't.
Right.
That's what the Delaware court should have done. This is not our business.
This is years ago. Right. Yeah. So it's hard to tell what Delaware is going to do. We kind of expect maybe some companies to try this out.
Yeah, they're going to try it out eventually, and and it's particularly valuable at the IPO stage, as I said, because that's when you can be potentially liable for Section 11 claims, which don't require showing of intent. Now, the thing is that I don't know if somebody's going to bother suing just because you adopted one. It's really the rubber's going to meet the road when
they have a legitimate claim, when they have something
when
about
there's a securities claim. I hope. I can only hope plaintiffs are really smart about it and they, can try to identify a really strong securities case that.
Well, the IPO market's picking up, so.
Yeah, we'll see.
There'll be some more of these,
Or plaintiffs can just sort of try to make life hell for a company that adopts one by bringing lots and lots of individualized arbitrations by well-heeled institutions. That'll make companies
that's going to be.
it.
There's again. I started alluding to this. There's an increasing, from a very low level, appetite among at least activists to consider litigation about this kind of stuff. So there conceivably could be, in a given company that's run into problems, 2 or 3, a small number, a handful of investors that, they wouldn't necessarily be colluding over this, but could be looking at this, or could be talking to different attorneys and saying, have you thought about starting an action against a company? It's going to have to go to arbitration, but fortunately, what's nice about arbitration to an activist is it's fast and cheap, or faster
it's fast
and
cheap
cheaper.
And private. So and if you don't necessarily want to create a public record of what you're doing,
right?
So
I could see, at least among the activist community, and I'm talking more financial active. I have no idea how if ESG folks would be interested in this. Some willingness to kind of go along, and again, I've had very little interest over the years in like securities class action stuff. It's just it always struck me and others as sort of the realm of smaller shareholders that got cheated over something, but there's always kind of the tinge of aggressive plaintiffs lawyers kind of looking for.
I know.
No. I'm saying that's sort of the environment that we think about it in. But there are lots of legitimate, claims that maybe this can actually be a little easier. So maybe a little bit of a silver lining here.
Yeah.
At least for bigger funds, bigger activists, and so forth, to try to get redress for some sort of some sort of prospective fraud.
Yeah, especially because you don't have all those judicial barriers. But I mean, I'll just leave it at, I think it would be a terrible thing to lose securities class actions.
Wait a second. If the outcome is none of these ever, that's going to be a problem, because it does serve as an effective check, at least on some of what boards try to do.
Yeah. I think it's a deterrent. I think it's a deterrent that helps keep boards honest. I mean, I don't think the SEC the SEC has repeatedly said, Congress has said, everybody understands the SEC does not have the resources to police the entire market.
To enforce. Right. This is just how the U.S. kind of system has evolved, is that you need all these kind of private as opposed to government regulatory actions to try to keep companies in check. And I agree with you that companies kind of bitch and moan about how bad this is, but they're bitching and moaning about shareholders doing some of the only stuff they have available to them to try to enforce their rights.
Yeah, and I'll just add the other thing is that even if the stuff moves into arbitration, first of all, I don't know if it would be nearly as effective as a deterrent as class actions are. But the other issue is the law doesn't develop. Like, we don't see it, we don't have any insight into it, we don't know what's happening, and we don't know what the legal standards are. I mean, the law is just frozen there, and I think that's just bad system.
I agree that one reason we're talking about some of the advantages of Delaware is that they have developed over decades a progressively more detailed and sensitive, or whatever, body of law, which is largely outside of statutes, all cases. And if we don't see any cases, you're right, it's going to sort of put all that development on hold. And there's stuff to talk about. There's all sorts of new markets, and there's all sorts of new things where there's going to need to be public stands on how to mediate fiduciary duties in an evolving environment, and that's going to come to an end.
Yeah,
and that would be unfortunate.
That would be very sad.
So speaking of coming to an end, I think we should probably wrap this up.
Yes, I think that's a lot.
But this
is
really
strong feelings.
Well, I mean, we'll return to this when we first. We should make a note when we see the first case. We'll see not the first case or the first bylaw amendment, and we'll make a note. You'll probably put it in your blog.
Yeah,
right?
Probably.
You'll mention it in
I'm
Business
sure I
Law
will.
Professor blog. So, all right, cool. And I'll repost it. All right, let's. As we said, we're going to come to an end. We're wrapping up, Anne, and it's been good talking about this. We'll return to it sometime soon. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is Professor of Law and Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com, and Ann is at law.colorado.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We will see you again soon.